Brenda, good evening and thank you so much for joining us. Much of the morning was all about who is part of the application by President Jacob Zuma to interdict the release of a state capture report. Are you able to break this down for us?
Well, essentially, good evening and good evening to all the viewers at home. Essentially, what happens with intervening parties is that ordinarily when you bring an application, you ought to cite as many parties as possible, and to the extent that those parties have a direct and material interest in the matter. Now, the COPE, the Economic Freedom Fighters, the Democratic Alliance are essentially arguing that, well, the DA is a bit different because they are saying we are the ones who lodged a complaint with the public protector, and the EFF, COPE, and the United Democratic Movement, on the other hand, are saying, look, we are here as representatives of the public. So in order for us to discharge our duty as members of Parliament, as elected representatives, we want this report made public. Then there was the other person who applied to intervene was Faiki Mentor. And with her application to intervene, it turned out in court that she is also saying that she fears being cross-examined by the president and for him to test her version because she wouldn't feel safe unless, of course, it's done under the auspices of the public protector and under her supervision. Now, the judges essentially granted. We had applications the entire day, and the full bench of the North Gauteng High Court then granted those applications with costs. And I kind of quivered a bit when the representative for the president, stood up and conceded to costs. And obviously, costs follow the cause. The successful party is normally awarded costs. And, just as I was about to speak, Advocate Dalimpofu SC stood up and said, well, we accept that they have conceded and around the issue of cost, but we also at a later stage want to argue whether these funds should be coming from the fiscus. So those were the intervening parties. They were all successful. And obviously, Minister Des van Rooyen's application being dismissed with costs. And so the matter continues tomorrow.
Now, Brenda, can the court allow the president's plan to ask that the matter be postponed to allow him more time to read through additional affidavits submitted by people opposing his application?
The proceedings today kind of give me a sense of where the court is going. And if indeed I was in a position to advise the president, I would say, it's time to withdraw this application because the president has a right. I don't, and this is where I argued with what was otherwise a brilliant argument by Advocate Mogaitobi, whom I believe argued exceptionally well in court, when they basically say that, the issue of the president's rights, his procedural rights being afforded an opportunity to cross-examine these witnesses is something that can follow. He can raise that during a judicial review of the public protector's report. That is almost akin to saying to someone who is in a magistrate's court, well, this magistrate or the prosecutor, whoever it might be, is going to ride roughshod over the rights of the accused person, not afford them an opportunity to state their case, and then say, well, there are review proceedings in terms of the Criminal Procedure Act. We want to do this and we want to get it done. Because I felt that there is substance in that aspect of the president saying, look, all I'm asking for is a 60-day period within which to basically argue. And understandably today it wasn't about the merits of the case, it was about urgency, and it was about granting the intervening applicants an opportunity for them to be heard. But, you know, yesterday Christine Kunda said on Twitter that our country is going through a nervous breakdown. I think that we should really step back and ask, is this litigation in the interest of South Africa? Yes, they appear to be rights of the president that have been violated, but in the grander scheme of things, all this is going to come out. Facimento has been allowed, meaning that things that are related to the report are going to come into the public domain in any event. I saw on Twitter someone saying that it had been leaked to the BBC. I'm not sure how true that is, but I just feel we should put this matter to rest, have this report released, have it challenged if the president and all the other applicants wishes to do so, so that as a country we can actually move forward.
Now, Brenda, just speaking of the release of the report, the UDM argues that President Zuma wants to prevent the release of the report because it could be used to impeach him. Does this argument hold water?
Well, I don't think so. There is no way that this report is not going to be released. Let's look at a situation where the court concedes and says to the president, well, indeed, you have a right in terms of Section 8 of the Public Protectors Act to cross-examine these witnesses. You weren't afforded that opportunity, and we are granting you 60 days within which to do that. After that 60 days, that report will eventually have to be released.
Now, how do you think that live broadcasts and coverage of such cases affect their ultimate outcome?
Well, you don't, I can't. I've written articles on open justice and what it basically does, because public opinion is not supposed to impact on decisions that courts make. But, you know, as we continue and we listen to some of the utterances, you can tell that those judges are not like monks who live in seclusion. They are very, very alive to the politics of the day, which in certain instances I think is actually regrettable, because we cannot begin to be caught up in a scenario where even our judges appear to take a certain stance, but the public opinion cannot be ignored.
Brenda, thank you so much for joining us. We have to leave it there for now. That was legal analyst Brenda Wardle joining us via Skype.